then it's Dumbe.
What about
OANDO here?
Yeah, Mr. Chairman, OANDO is here.
Yes. Is it 12?
No, sir.
Okay, Mr. Chairman, I, Engineer Chris Eche, do solemnly swear that the evidence I shall give before this distinguished committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. Please come up your mic. As you were taking a vote, the distinguished member of this committee walked in, so let me allow him to introduce himself.
Here, man. Here comes Samson. I represent the Father of South.
Sir, what is your name?
My name is Chris Eche,
And you present,
OANDO Energy Resources.
what's your position there, sir?
I'm a division manager of public affairs.
Okay. Now we have a letter on record from the petitioner saying that this matter is before the House of Rep. And also that you are already talking settlement. And therefore, he respectfully request that we step down this matter. Is that your understanding?
Mr. Chairman, yes, the matter is before the House of Representatives, and we are just following the procedures there.
Okay, very well. Not that we cannot hear this case because it's there, because it's also before us, but because the respondent himself has sent me a letter to withdraw the matter from here, we will oblige that. And so for that reason, we're going to step down this case and adjourn it sine die. I do so because we don't wish it's going to come back. All right? So this case adjourned sine die. Thank you.
Thank you, Mr. Chairman.
Second case.
Second case number B. Deborah Stephen Tukura of Nigerian. The petitioner, Deborah, is present. Nigerian Army is present. Deborah,
Yes.
take your seat.
Sophia.
Sir? Okay.
I, Deborah Stephen Tukura, do solemnly swear that the evidence I shall give before this distinguished committee shall be the truth and the whole truth and nothing but the truth, so help me God.
Are the respondents here?
Yes.
I, Major General Abuja, do solemnly swear that the evidence I shall give
before this distinguished committee shall be the truth, the whole truth, and nothing but the truth. So help me.
All right, Madam Deborah, could you please tell this committee what you done?
It's okay if I read it.
Just come to us. If you want to read it, that's fine.
Okay. I, Deborah Stephen Tukura, write to formally petition on behalf of my sister, Stephanie Stephen, and I, orphans who lost our parents over 10 years. Our late father, Engineer Albert Stephen, bought this land from Denobly Integrated Limited in 2012. We made efforts to take ownership of the land, to penetrate the land, and we met hostility from the local community until we were able to pay the economic tree compensation to the indigents, the Bassey community. After which we cleared the economic trees, dug trenches for fence, dropped over 5,000 blocks, chips of sand and gravel, attached our photos to the committee. One day, the Army Estate Management came with vehicles and armed militia officers and ordered for shoot at sight and denied access to the land, and the continuation of the fencing of the property. All efforts to access the land has proven abortive. Also, efforts have been made to ascertain the status of the land, which we wrote to Director Urban and Regional Planning of FCDA, dated 27th July 2023, with no response. Thereafter, we complained to our Honorable Senator representing Adamawa's South Senatorial District, Senator Reverend Utiaruk, who kindly wrote letters on our behalf to the Honorable Minister of Federal Capital Territory, with copies to the Director of Land, Director of Development Control, Director of Urban and Regional Planning, all on the 15th of October 2024. And this is our last resort. We felt compelled to petition to the Senate to come to our aid to help us recover our land. Our prayer is that the committee assist us in recovering of our property back, and also we request compensation on the loss of our materials, cost incurred, and pain and suffering. Thank you.
Thank you. Some of the mic, please. Move this people to Nigerian. Are all officers on the same case?
Yes.
Okay. Please introduce yourself.
Distinguished Chairman of this Senate Committee on Ethics, Code of Conduct and Public Petition, Vice Chairman, other distinguished editors and members of the committee, I am Major General N.B. Onojan, Deputy Chief of Civil Military Affairs, representing or heading the team from the Nigerian Army. Other members of the team with me are Brigadier General Buchi, who is the Deputy Director. Buchi, please. Buchi? Yes. Okay. He's the Deputy Director of our Liaison Office in the National Assembly. We also have Major Bima from the Legal Services. Say again, sir?
Spell Bima for me.
Bima, B-I-M-A.
Legal Services.
Yes, sir. We have Captain Anini from the Post Housing Development.
Captain Anini?
Yes.
A-N-I-N-I. Is that a good man? No, please.
So what? That's what I was thinking.
But I think, Major General, what's your name?
Onoja. Onoja. O-N-O-J-A. Yes, sir.
Okay, you are all from which of the divisions?
No, sir, we are from the Army headquarters.
Army headquarters. All right, listen, before you start, I have like I told you, where you are. Okay, come. As I said in my opening, I said as we proceed, other members, distinguished members of this committee will be and so we have two other members that just came in. I will give them the opportunity to introduce themselves.
Chairman, colleagues, My name is Senator Ide Dafinone, representing Delta Central. Thank you, sir.
Thank you, Mr. Chairman, distinguished colleagues. Yes, my name is Senator Deborah, and said that you can know the vice chairman of this committee. Thank you so very much. So, I was listening.
So earlier I introduced myself and
Why? Come with your
okay, sir. Other members include Sophia, Anselm, and Barrister Charles Jonah.
Also from the Army headquarters?
All of them are from the Army headquarters, Department of Post Housing Development, who are in charge of managing Army properties, including the one under contention. So I will first I want to start by thanking this committee for giving us the opportunity to respond to this petition. We are fully committed to cooperating with the committee to reach a logical conclusion on the matter, so that at the end of the day, justice will not only have been seen to have been served, but to have been served adequately. So the land in contention, it was purchased by the Army for use, and it was allocated to an Army scheme for post-housing development to provide.
Do you know when it was purchased?
Yes, sir, in 2020.
When did it took place?
So in our response, the relevant documents are all there, all the receipts. But it was purchased in 2020.
In 2020?
Yes, sir. All the receipts are out there.
Purchased, what dimension of the land?
So it is in phases. Okay? There are 5 of them. If you go to Annex A, you will see all the details there.
Yeah, but when you are talking, I want to hear you.
Yes, sir.
What is the dimension of this land? Is it 1 acre, 2 acres, 3
No,
acres?
no, sir. We have about 5 portions. There's 20, 20, 20, 3.5 and 16.5.
Acres.
Yes, sir. Acres.
So, madam,
All in
what is the
Dumbe.
dimension of your land?
Sorry, I'm not really sure how to
Is
say
it 1 land, 2 lands?
It's
One
a-
land?
It's one.
1.
Yes.
So I'm trying to proceed this carefully. Meaning that one is inside the land that the claim is the Army land. Am I correct?
Yes,
Yes.
sir.
Okay,
Something
fine.
like that.
Okay,
Yes, sir.
fine.
Yes, sir. Yes, sir. Yes, sir. Okay, sir. Sir, she is alleging, the petitioner is alleging that the Nigerian Army Estate Management approached or encroached on her land with plot number CD 4099. That was what was contained in her petition at Dumbe 1, which her father handed over to her sometime in 2012. It was stated that prior to the alleged encroachment, she was unable to claim ownership of her land as all efforts were met with hostility. I think she said that here. She mentioned the issue of economic praise and that the Army Estate Management went there with armed soldiers. That Army Estate Management is the Post Housing Development Limited. She also made efforts to ascertain the status of the land sometime in 2023, and then there was no response from her. She copied the Director of Federal Capital Territory Administration and some others. So what we just want to say is that when this petition first came, I think we also met with our own surveyors to pinpoint the exact portion of the land that is in contention. It's on one of the sketches on our Annex B or so is there. The portion of the land that is for the Army is there, and then the portion that she thinks is hers is there. But because her land is CD 4099. And there is no portion of the Army land there that is CD 1499. Now, the Nigerian Army Estate Management that was mentioned is the Post Service Housing Development Limited. It's a registered company with the Corporate Affairs Commission, and the registration number is also in our response. The mandate of the PHDL is to provide affordable housing for both serving and retired personnel and the general public all over the country. In line with this mandate, between 2020 and 2022, the PHDL acquired some plots of land from various vendors situated within Dumbe 1 extension. All the details of the land that were acquired, those 5 portions of land, one is 20 hectares, second one 20 hectares, third 20, the fourth one is 3.5, and the fifth one 16.5 hectares. They are all there in Annex A to the document that we submitted. The acquisition of the plots was diligently carried out with detailed agreement between the sellers and the PHDL. Photocopies of all the sales agreements are attached in the document that is before you. Prior to this search, prior to the acquisition, a search was conducted and the plots were validated to be genuine by the FCD as contained in the layout. The layout is there as Annex B. The layout of the land was allocated to the Army. Other documents concerning our transaction between FCD and the Army are all contained in that binded document that we submitted. All the plots that were acquired by us bears numbers as contained in the layout and the sales agreement. As I mentioned earlier, however, none of the plots bears the number CD 1499.
CD 1499?
Yes, sir.
That's the land sheet.
That's the land sheet is claiming. If you look at the sketch that is before you, it doesn't have that number there.
That one?
No, sir, not there. So, although upon physical visit to the site, she pointed at a portion of the land that is plot CD 1499. But our documents do not support her assertion.
The documents were given to you by
FCD, yes, sir.
FCD.
Yes, sir. We have all the documents, the photocopies, and that binded listing. Unfortunately, sir, the plot numbers that she is claiming as CD 1499 are on the sketch that was given to us, which we processed in the FCD as ED 1418, ED 1419, ED 1420. That is on Annex C. You will see them there. That is the portion. We also marked it out on Annex B. It is to the left top side of the land allocated to the Army. So, sir, we are currently constructing houses for soldiers under the affordable home ownership option for all our soldiers on the plots as a reward and morale booster for their hard work, dedication and sacrifices to the nation over the years. The scheme is designed to ensure that all our soldiers have access to affordable housing after discharge from service. With this in mind, sir, I'm not sure that the Army did anything or is going to do anything that will jeopardize the future ownership of those houses. We believe that we follow the due process in acquiring the land, and all the documentation we have it. Contrary to the allegations, the construction workers of PATL are currently working on that site daily, and the place is open to members of the general public who may wish to go there. Our prayers is that, respectfully requesting the committee to discountenance the petition for lacking in merit. I am to also humbly add that the committee please direct the petitioner to channel her grievances to the appropriate forum of government agency empowered by the National Assembly to challenge the ownership of the plots. We have all the documents, and they are in this binding document that was presented to the Senate for the everything is there, all the receipts, the purchases, all the vendors that we bought it from, everything is there. The year we bought it, everything is there. So I'm sure, sir, that there is a mistake somewhere. We don't know. We don't know. So, yes, sir. Distinguished members, the position of the Nigerian Army is that the land is legally ours and it is legally acquired. We want to restate that the Nigerian Army is a law-abiding institution that seeks to maintain cordial relations with the society. We don't want any challenges, but of course, if we legally purchased land or any item, it should be treated as such. We thank this committee and the entire members for their warm reception. I wish to conclude by kindly requesting for a resolution of this petition so as to restore the good image of the Nigeria. To conclude, I wish to convey the utmost regards of the Chief of Army Staff to this esteemed committee. Thank you.
Thank you. Thank you so very much. One question that I actually have for you. You said that both parties went to inspect this land. Is that correct?
Yes, sir.
Did the FCDA person go with you?
No.
So to
Just we and the
okay. Let me give my colleagues time to. All right. This is my position on this. Yes. Go ahead.
Thank you, Mr. Chairman. I wanted to inquire as to whether surveyors have been brought into this dispute. So, where she believes her land is inside yours and you believe her land is not, the various sales agreements and documents from the Federal Capital Territory will give no, they will give points of reference that cannot be disputed. And so with reference to those geographic points, the surveyor who visits should be able to say whether the land is actually included within yours, and then verify the documents of purchase that each party holds, and be able therefore to resolve the issue. So my thinking is that the first port of call would be to have consulted surveyors to verify documents before getting even to this stage. Thank you, Mr. Chairman.
Thank you so very much. If I heard you very well, sets of yours went with you to the site. I think I heard that.
Yes, sir. The two surveyors. There was
Yes,
there was a team from her side and from our side who went to inspect the place, and then they brought out the issues. Of course, we didn't go with FCD because we have our documents, but maybe going forward that can be done.
Madam, has you said anything that you disagree with?
No.
Okay. So,
Unless that's bilateral.
unless I what?
Okay.
Unless I what?
Unless the statement that it doesn't belong to me, that's all I know.
Oh, okay.
Yeah.
Okay, you want to say
Yes,
that?
yeah.
All right. Now, I think a crucial person in this whole affair is that's the FCDA. completely missing. So we are going to invite FCDA to come and determine where her plug is. Her plug will very well be somewhere else. We don't know. It might very well fall within your estate. That also we do not know. But she said she purchased, I'm looking at her document. We have the hour of O that dates back to 2012 by her father. And then she went to pay for economic crop in 2020 as thereabout. And then gross is after 2012. So I would invite the FCDA to come and tell us exactly where her land is and where your land is. Because even the beacon numbers is different. The beacon number is so different from her own beacon number. Yet she's saying that the beacon number land falls within your estimate. I don't think there's much you can really do here unless FCDA that gave you the right to your land and also give her the right to her land to come and tell us where the discrepancy is. Do you understand what I'm saying?
Yes, sir.
Yes.
So if we agree on that, and unless my colleagues have a different views, and I will allow them to express that. Okay. So if that's the position, we also vote here. So therefore, we are going to adjourn this case and invite FCDA to come specifically with the information to the two land. So we will know at that point where her land is. Am I clear?
Yes, sir.
Very well. So we'll adjourn this case. Where's the clerk? We will adjourn this case now for us to invite the FCDA. I don't know when we can have, how quickly we can have this, because you are already building.
Yes, sir.
You are already.
Mr. Chairman,
Okay, so
if we are applying to the FCD and they are already big, if you stop when we hear the numbers and the petitions start to go on, why must you the petition? So let party petition support starting when they come and come. We are not confused.
okay, in that case, we're going to give you a very short clerk. Which is shortest thing to come.
Sorry for not introducing my name. Mr. Chairman, my name is Jimo Ibrahim, CFR, and I represent OANDO South, and I'm the chairman of the Parliament Committee. Thank you.
Mr. Chairman, very colleagues, I am Ezekiel, representing Kogi East. You are all welcome.
Yes. Are we clear?
Yes, sir.
Very well. So we'll adjourn this case to the 10th of July. Quickly, so that we can unbundle what has been bundled. Yes, and like my colleague had advised, that we should maintain status quo because we don't want you to continue assuming that the land falls within your land. We don't want an irreparable damage done to her.
And once you prove that it is your land, we have no other option. What do you do? Or give us that opportunity to hear both sides, and then also because you are at the top level, there are so many people will not think there is suppression or liability there. It's for your own interest. It doesn't take the chairman of just so it's short time. In 24 hours, we clear out the case. If it's your land, continue. If it's not your land, we give you one who feels it's not your land. And then that goes on.
All right. So as a result, therefore, this case is adjourned till the 10th of July 2025. Well, I hear that now on that matter was sick. That was not matter. Yes, sir. We're
Distinguished member of the committee, the student matter for the day is a petition written by Joseph Akoko, that's Nigerian. This is the second hearing of the matter.
Tell us why you're here.
So I should I suggest you something?
Sit down, please sit down. Please sit down.
So I applied to this committee that my application for redress of lawful dismissal from the Nigerian.
Speak to the mic, please.
I applied for the redress of wrongful dismissal from the Nigerian appeal for a statement of I-95 million before 2009. I wish to apply to rewrite an appeal for redress into the Nigerian stated below. Statement of offense, award, introduction. I was enlisted into the Nigerian in August 1995, and I was posted to 26th Battalion, Lagos. My unit located from Lagos State to Sokoto State in 1997. I served with 26th Battalion in some foreign missions to Akoko to 2000, and UNAPSI from 2001 to 2002. All in Sudan. I was also trained by the 3rd Special Forces Group Airborne, the Operation Liba, as M60 and machine gun in 2000. During for 10 years before my wrongful dismissal by Lieutenant Colonel Agip in March 2005. My brief factor of my case. I was granted for 3 days class, 14 days waiver class from 4th November to 17th November 2004 for the burial of my elder brother. While at home before the expiration of my class, I developed a acute problem with swollen face and post-discharge. I was admitted at Akoko Clinic and Rutail, Ezekiel, Benue State, on the 15th November 2004, and I was discharged on the 24th December 2004, and I was given 2 weeks pass, 2 weeks excuse duty, by the doctor that treated me, as if it was not enough. As I was reporting on the
29 December 2004, I had a stress neck bite on my left leg. Was too severe as if
You can take some time to catch your breath. All right? Take your time to catch your breath.
as if the pain was too severe as if it was to take my life, and it led to my admission at General Hospital, Sankara, Benue State, and I was discharged on the 16th of February 2005. Those strange occurrences made me believe that there's something somewhere. But I could not exactly know what was the cause of the problem. I attached here with the medical report and the photocopy to prove those. For I reported back to my unit on the 21st February 2005, despite the fact that I was not fully recovered from the attack. All my unit which are served for 10 years. It was to detain and charge me for award. I was tried and dismissed on the 13th March 2005. One of my relations who was a police officer, SP, the late SP, also sent a signal to my unit in respect of my sickness and hospitalization from Okon and I really confirmed receiving the message. Without for interest, I did not commit any offense. I did not commit the offense. I was charged, tried, and dismissed. I was officially given pass by my unit, and before the expiration of my pass, on the 4th to 17th November 2004, I fell sick and I was admitted in 2 different hospitals. For several strange ailments, I was to state that I did not commit any offenses and by what was provided in the past, that if sick while on pass, report to the nearest medical officer and show this pass. I also collected medical reports from those hospitals for the avoidance of that. My wife and my children were in the barracks, Msughter, which that was not easy for communication, and which my unit could not trust me or send my wife about me. But all my unit, which I served for 10 years, notoriously years, would do this to dismiss me just because I was sick. When I reported back to my unit detained me for 21 days, thinking it was a punishment for the unit, and my unit now proceeded my orders again for dismissal. During the time of my orders, my unit also seized my pass and told me, not knowing that I had a photocopy. I was not given fair hearing, and I had not been charged nor tried for the army. My unit did not care to investigate my circumstances, which led to my award, or set up a regimental inquiry to ascertain the truthfulness or otherwise of my claim, but only dismissed me because to the fact that necessitated my award for which I was dismissed. This is also against the principle of fair hearing. If I would have given up the ghost at home, my unit would have not given me a befitting burial because I was on official pass and fell sick. 7, based on the above ground, I humbly appeal to the authority to consider my case and reinstate me. I am married to children and aged parents at home. I have pleaded before that did not share any from the authorities. Hence, I wrote again because of the confidence I have in the present leadership of the Senate in particular, and the government of Nigeria at large. Long life the Senate, Republic of Nigeria, long life the Nigerians, long life the Federal Republic of Nigeria. Thanks and prayer.
Thank you. Please come up with my table. Thank you so very much. That was quite emotional. Sir, what's your response to this?
The chairman, sir, other members of the committee. Thank you once again for the opportunity to respond to this issue. From what I can see, this issue has dragged for the past 20 years or so. Personally and as an institution, we feel its pains. However, sir, we all know what the military is all about. It's an institution that stands for order. It's an institution that we must have discipline. If we lower the bar or the standards of discipline in the military, you all agree with me, Nigerian would have been a different society, probably would descend into Sierra Leone or Liberia. But because the officer corps, the leadership, has maintained the standard of the discipline in the Nigerian army, that is why everything is looking as if it's easy. While we understand his plight, from the various reports that emanated from 26th Battalion where he was an habitual release, that's absent without leave. From the information available, by the time he was finally dismissed, that had been the 5th time that that incident had occurred. We always try to mentor them that, look, if you have a problem, you must communicate with your superiors. And in the course of your career, you must build your integrity to the point that even when you say that, I know he's anchoring his complaint on the issue of illness when he went to the village. But assuming that he had built confidence in his battalion commander or his officers in Sokoto, I can bet you, sir, somebody there would have said, no, they are aware of his ill health. But because of the persistent reports, prior to this particular incident, 4 other incidents, nothing was done. And so a decision was finally taken that in the interest of maintaining discipline and cohesion in the unit, one individual should not be allowed to continuously get away with breaking the laws of the army. And that is in the military. It's not about shunting anybody. All of us are officers. My soldier is behind you. If he doesn't commit an offense, nobody is going to disturb him. But if he commits an offense, he will never go free. It's not wickedness. It is the way of the army. And so, on that note, I still say so. Despite our sympathy with him, we must take every step to maintain the sanctity of our institution. Thank you very much.
Thank you.
Thank you, Mr. Chairman. I have one point I'd like to clarify with Mr. Akoko. On the second page of your presentation, under grounds for redress, you say, and I quote, "I want to state that I did not commit any offense as I abided by what was provided in the past, that if sick while on pass, report to the nearest medical officer and show this pass." I understand that to mean medical officer within the Nigerian Army. Can you please clarify that you presented your pass to the Nigerian Army while falling sick on your pass? Thank you.
Answer.
Sir, I believe to what I've seen in the past and objecting by the Nigerian means, when you are on leave, and when you are pass, and when you get sick of this my nature, the medical officer, this is the one, any of the medical officer that will treated, even it's not close to any limit for you to save life before anything.
I'm sorry, Mr. Akoko. My understanding would be that medical officer referred to in an army pass would be an army medical officer. So the nearest army medical officer is the person you should present your case to, that you are ill and cannot therefore return to base.
Yes, sir.
Did you present it to an army officer or not?
No, sir, it's not the army officer. Where I was in the village before I had this problem, and I reported to a medical doctor that Rutail, not the director, or says he's a medical officer from army. But I believe when you are sick, you have to submit it to a medical officer who will save your life for the army.
All right, turn off your mic. I have a few questions for you. You were dismissed in 2005. And your petition came in, well, when you were dismissed in 2005, what did you do to redress your dismissal?
That is, I've been writing in many places. I've been writing to the channel like human rights, Nigerian, where I will be considered, I will be stated to appeal my authority, the Nigerian authority. Because to me, I've never committed an offense.
No, I understand that.
Yes.
What steps did you take? Because the records are available to us here, provided by you.
Yes.
Was a letter to National Human Rights Commission.
Yes.
And that was in 2013.
Yes, sir.
So between 2005 and 2013 that you wrote to the Human Rights Commission, what did you do?
And I've been sending reply to army.
You be what?
They have been sending reply. They have been sending to army that they communicate army. Let them do something for the army. Let them do something on my behalf to reset me. I believe that is why they were giving me those.
I know.
Yes, sir.
You were dismissed in 2005.
Yes, sir.
6, 7, 8, 9, 10, 11, 12, 13. 8 years.
Yes, sir.
Before you took the first steps to go to Human Rights Commission, is that correct?
Yes, sir, for human rights. After I been
So before, that's the person I asked. Before you took that step to go to human rights,
yes, sir.
what did you do?
At home.
So you were just at home?
No, sir.
Eh?
I was not just at home.
So what did you do then? Tell this community
I was
what-
working with community.
Okay, so between the dismissal in 2005 to when you woke up in 2013, You were working with the community.
Yes, sir.
In what capacity?
In the security capacity, as I was
You were working with the community as a security man.
yes, sir.
Were you paid?
No, sir, it was.
Were you paid by the community?
I was just an assistant.
Were you paid by the community?
I was paid.
Did you, okay, so you got another job with the community?
Yes, sir. Vigilante, sir.
With what?
Vigilante. In my home.
Vigilante?
Yes, sir.
And you were being paid as a vigilante in your community?
Yes, sir.
Okay. So then you now came up in 2013, all of a sudden, to go to human rights. And then human rights, how did human rights handle your case? What happened at human rights?
There's a letter from 2007, sir. 2007 before the one again, 2013. There was the one in 2007. Before 2010, it's a past year, if I'm not mistaken.
Well, I'm reading the document that was submitted to me, to this committee, is what I'm looking at here. Okay. All right, so clearly, between 2005 and 2013, you got another job with the community and you're working as a vigilante,
Yes.
for which you also paid. All right. The record provided by the Army says that this is not the first time that you went AWOL. That this incident is the 5th time. There are 4 other incidences where you went AWOL, as documented by the Nigerian Army, by your employer. Do you dispute that?
Yes, sir, because while I say I have not committed searches, I've never won a charge on a war or determined that I've been on a war.
But have you been reprimanded? Has it been brought to your attention that these incidences of AWOL?
What happened is I have some copies here with me that when I was on pass, the other time I had a problem accident with my car. That even is here with me that I should.
Okay, so that's one of the 4 times.
Yes.
Second one of the 4 times, what happened?
So they did not charge me because when they see the evidence even at the hospital, when I made it, in fact, one of my relatives was a police officer who was at Sokoto Sani, who was at home, and he took my pictures to them in the unit to know that I'm admitted because my radiator burned me all over my face. The pictures are here with me. I was never in charge. So once they see, they consider that yes, this is, and I have those pictures here with me. If I may tell you for this.
I have the petitioner was lawfully dismissed on 30th March 2025 following a summary trial by his commanding officer. Is that correct?
Yes, sir.
Were you tried?
Yes,
In
sir.
2005?
Yes, sir.
It was as a result of that trial that you were dismissed?
Yes, sir.
In that trial, were you also confronted with your other incidences of AWOL?
No, not.
It was based on only that incident?
Yes, sir. I was detained for 1 month, that is 21 days, before I was tried and dismissed. They did not put any difference of me being on a war. Before God and me.
Was this case did you ever go to House of Representatives?
That's sir.
Did you ever take this case to the House of Representatives?
Yes, also.
When did you take it there?
Yes, sir.
In 2007, right?
Yes, sir.
And what was the outcome of that hearing?
That was that the rep that represent the case there, and then that, okay, hence I was on sick, on condition of sick, and I'm back, I'm ready to do my job. Then they should, the army should consider me and respect me. And the officer that was there said, no, you cannot do that, or you cannot say, consider on this ground, or say that that's all he told me, and they quit from me.
Mr. Akoko, let me remind you that you are under oath. That you can't, please don't come here to mislead us. Because if we also take the measure against against you. The reason why you go on oath is to come here and tell us the truth, so we can assist you any way we can. But when you begin to speak here and there, it bothers me. This case was already, see, the House of Rep will not dismiss your case without a finding. We will not dismiss this case here without a finding, if that is what we're going to do. So don't let me go back to those records. And don't lie on that oath. So let me ask you again. In 2007, you took this case to the House of Rep. What was the outcome?
That they addressed me that I should, the rep who was in charge, the student who was in charge, they told me that, he told the army that hence I was on pass, and I felt sick, I was saying that they should consider me administrative. But the officer there could not, because he said he will not pay for it. That's why I still follow on for the other place.
No, you also stated here that you didn't have a fair hearing. That's what you said, you didn't have a fair hearing.
That is in army, sir.
You said you didn't have a fair hearing from the army.
Yes, sir.
But you also admit here to us that you were tried.
That is my unit, my company commander.
Yes, I mean this is like the procedure.
So when I went to CO, my commander.
No. I like the stories, but I don't want to hear much of it. Were you tried by the army on this matter?
That is from regimental. I was not tried. From regimental police, that is military police. They did not try me.
Who tried you?
It's my senior.
Does it is it within his right to try you?
Sir, I believe in army.
No, I know what you believe. You are in the army.
Yes, sir.
You are in the army.
Yes, sir.
You know the procedures.
Sir.
Your regiment say tried you.
The regiment does not try me.
Who tried you?
My company commander. That is
it your company commander that gives you the pass? Is it your company commander that you report to?
I applied to him before they moved my application to my battalion headquarters. When you apply to a company, they now move your application to the battalion headquarters, then the commanding officer will.
No. Listen. It says the petition was lawfully dismissed on 30th March 2005 following a summary trial by his commanding officer CO based on powers conferred by the CO by the Eastern Law at the time of the trial, which was Armed Forces Decree AFD number 105/1993. That's what I'm saying. So you were tried under their law, right?
Yes, sir.
And if you were tried under their law, will you then say that you didn't have a fair hearing? Were you allowed to defend yourself there? Did they ask you a question?
They just asked me that am I on pass? I said yes, I was on pass. And I faced it. Then my CEO said, okay, I was not on pass. I should present my pass. Then I removed my copy of my pass and I presented it to them. And they tore the pass. They tore the pass.
The officer who was hearing your defense tore the pass?
Yes, sir.
Why?
Sir?
Why did you tear the pass?
I don't know that I'm not on pass. I'm now.
All right, officer, you heard him. Yes. I want to zero in on the issue of fair hearing. Yes. He's saying that he was not given a fair hearing, and that his pass. Turn off your mic, please. And that his pass was torn when he presented it to show that he was given a pass to go to kill himself or for whatever reason, to bury his father. and that when you presented that pass, that your officers tore it, but that he had, unfortunately or fortunately for him, he had a copy of that pass, which he presented here. What is your position?
So, Mr. Chairman, sir, other members of the committee, so as I said, I understand the situation he's in. However, even as you can see from his description, there are a lot of inconsistencies in what he's saying. In the army, nobody can victimize you for not liking your face. And as our response stated, sir, he was dismissed the 5th time this incident was reported. I'm happy, sir, that distinguished Senator definitely asked him about the procedure for extending his pass in Benue State. There's an army battalion, there's a brigade in Makoti.
Go ahead.
Yes, sir. All he needed to do was to probably find his way to that place and extend his pass. Even for the sake of humanity, let's take it that we'll accept the report from the police. We are not discounting that. We will accept it that the police sent the signal. So, but the truth is, even after extending that thing, he didn't show up until more than 30, 46 days or so after the board of inquiry. There's a procedure, he knows the procedure. Once your pass expires, you send, but you cannot even extend more than 2 or 3 times. You must take concrete action to show why we should allow you to continue to remain there. Once it was 14 days, 21 days that he didn't return after that pass, the unit was duty bound to set up a board of inquiry to investigate the circumstances under which he did not show up. All efforts to reach him were not effective. I think by the 46th day of his absence, after his pass had expired, when he heard that there was a board of inquiry, that was when he now showed up. So of course his pass has expired by the time he showed up in Sokoto. So sir, I don't know.
All right, thank you. I just want that clarification. I'm
Yes,
clear
sir.
about that now.
Yes, sir.
Gentlemen, distinguished. All right. For me, I think the matter is clear for what I can say. Mr. Akoko, it is clear, very clear for what I see here. Hearing you, hearing the army, and also reading your own response or your petition to us and their response to that petition. It's clear in my mind that you have 4 other incidences of AWOL. Even if I have to put that aside, I asked you a question before. You were dismissed in 2005. You took no steps. You did nothing until 2013 by your record, which is when you now went to human rights. And I asked you, within that period, what did you do? You were gainfully employed by the vigilante of your community. And I asked you whether or not it was voluntary or you were paid. I said you were paid for it. But I've heard you. I don't want to hear again. I've heard you. I'm summarizing what you said here. Everything is recorded, is on record. Say that again.
Sir, there's even a copy. The reference
Copy of what?
Have been written to the Army headquarters, Nigerian.
Yeah, but no. You neither go to court, nor did you come here. You went to human rights in 2013. So, okay, that letter you wrote, dated when?
This one?
Yes, the letter you showed me was dated when?
This one, the first one was from the Chief of Army Staff.
Was dated when?
26th May 2005. The other one, number 2, dated my GOC, 30th March 2005. The commander one brigade, 30th March 2009. The NDLA, one
Listen.
Division Leader Services.
Listen.
Yes, sir.
You were dismissed 30th March 2005.
Yes, sir.
That's when we were dismissed. The letter you are telling me is a letter of also March 2005, 2005. Abi,
Yes.
that's what you are saying. Okay. Between March, so all events occurred in March of 2005. And that's also the March 2005 that we were dismissed. Between that period, the letter again was now took actually 2009 and then 2013. In between, you were working. What I'm trying to establish here is that the army dismissed you. You actually took no steps to do anything, but you found another job which you want to do. Until 2013 that you went to human rights. And I don't know the outcome of that human rights. There's something on record here to say human rights concluded. Or is there a conclusion that you don't want us to see? But the only thing I see here is that you went to human rights. But what's the conclusion of the human rights? It's not here.
The other letter from the human rights has been directed to the army headquarters for response. And they did not.
Okay, the army did not respond to human rights. Okay, and so what followed? Nothing else followed. Okay. And then you now went to House of Rep.
Yes, sir.
That is the major action you've taken here. You went to House of Rep. And just listening to you, the House of Rep was trying to appeal to the army. The House of Rep was trying to appeal to the army to please take you back. Not that the House of Rep made the decision that it should take you back. And the army is here telling us that the indiscipline of what you did is what made them to take the action that they took. That's what I hear the army saying. And the army is saying that strictly, indiscipline will not be tolerated. We cannot make them change from that path, which is what the army stands for. The only thing I would have worried myself about if there was no fair hearing. And there was fair hearing because we were tried. It also bothered me that it took you, what, almost 9 years before you suddenly got up and said your rights were trampled upon by the Nigerian army. For me, you slept on that right, assuming you had one. And so coming here, we really cannot do much for you other than to ask, was there any entitlement as a result that the army did not pay you? When you were dismissed, before you were dismissed, when you owe salary, when you owe anything that the army did not pay, that you wanted to pay? If that's what it is, please tell us. On the issue of dismissal, we cannot reverse it.
Yes, sir. The other hand is, I've applied an army housing scheme.
You applied for what?
Housing scheme.
After dismissal?
No, sir, before that.
Okay, so what was the outcome of that application?
Because they are not in the award of a house, once you are serving in that whether dismissed or service for after 10 years, if you did not see your house loan that was awarded for you, they will pay you your entitlement with 50% on it.
Yes, what's the question of that?
Yes, sir. Mr. Chairman, members of the committee. Sir, I don't know, I just want us to generalize now that is it possible that you are dismissed from any institution and you get any benefits?
That's the question I'm asking you. So
yes, I said it's not possible, sir.
Okay.
Moreover, the regulation is that for you to be pensionable and get any other benefit is 10 years, and he didn't spend up to that in the system. So he did himself by his actions cost him a lot, and as a consequence of this continuous wound. Thank you, sir.
Thank you. Do you have anything to say?
Yes, sir. In the housing scheme, as we apply and awarded, they have indicated in the rules and regulation of it that if
even if you are dismissed, you are still entitled to it.
Yes, sir.
All right, so we'll investigate that. All right. Now, turn off your mic. I think we have exhausted everything we need to know here in this case. I'm satisfied with the question I asked you and the response I got from you. Also from the Army. Again, the Army, I thank you for responding to our request that you should appear and to explain to us what is happening with the petition against the Nigerian Army. Thank you for coming. On this matter, Mr. Akoko, we're going to dismiss it for lack of merit. Thank you. All the messages.
No, I don't want to put that there. Even if they request for that, they'll still give you. If they request for that, they'll still give
All right, thank you very much. But let me just dismiss adjourn the case where the absent is the responding is much less, so we just record it.
Distinguished members of the committee, the sixth matter I have today is a petition from Mr. Ezekiel Eriaye and Barrister Stephen Obiefule.
No, I want Mary Adiza, Eche versus Agip. That's the last one.
Okay.
Yeah,
Number 7 case is from Mary Adiza Eche versus Hydroelectric Power Producing Areas Development Commission, Aketewei. Did first year. Is Mary Adiza here? Aketewei, are they here?
Okay, Mary.
Aketewei.
All right, apparently your hyperlink is not here, but I also understand that this is the first mentioning of the case. This first mention of the case. We will hear you briefly from record, and then we will adjourn it because we can't take a decision now because the hyperlink is not here. This is the first mention of the case, and so we have to give them another opportunity to show up again. So, but let me hear you on record why you are here.
Thank you, sir, Mr. Chairman. Honorable members of the committee. I am here because of the non-provision of complete starter pack to beneficiaries of hyperloop transformation programs in various states. We the design best. We, the undesigned beneficiaries, humbly bring to your attention the grievous issue of non-provision of starter pack to participants of hyperloop youth transformation programs in various states. As trainees in the catering service categories, we successfully complete our training and receive our uniform and register claim. However, during the collection of starter packs at Akoko Stadium, Makurdi, on November 7, 2024, we were only provided with a knife and a set of spoons. Our givers, the specialty items include gas cylinder, oven gas, set of pots, blenders, rolling board, pan, and baking pan. Mixer were withheld by the organizers of the program. A starter pack incomplete and useless, and unless of the purpose indicated. Our case was like that of the biblical Moses, who saw the promised land but never entered into it. We saw these items displayed for pictures and videos, purpose, but thereof we were not given. So while pictures and videos in the media showed those items displayed, they were never given to us. Our prayers. We humbly pray that the Senate investigate this matter, ensure the provision of complete starter pack to all beneficiaries and taking necessary action to provide such appropriately in the future. Thank you.
You feel me, Moses? Turn off your mic. So for what I hear you saying is that we're in the program that was set up, it's a federal government program, am I correct? That was set up by Harvard in benefit of the youth, and then you are from Benue State. And then you successfully, what was the program all about?
It's a youth program it's a youth program where they empower, they teach us things.
So was the intervention gas and the rest?
Yes, what they taught us was, I was under catering.
Under catering?
Yes.
Okay, and for that, they were supposed to give you these items?
Yes, but they only gave me a knife and a set of spoons.
All right. How were you selected for the program? You applied for the program?
Yes, sir.
And you were selected?
Yes, sir.
Were you given a brochure or were you given anything that indicates that they're supposed to give you these things?
These are lobby, hyper.
Did you provide that with us?
No.
Please, can I see, take a look at it? Mary, I come here.
My name is number 8, sir. Number 8.
Okay, Eche, Adiza Mary.
Yes, sir.
All right. BSCCL.
Yes, sir.
What I'm looking for is a program description of what you will taught and what you be provided with after that training. The startup, that is startup kits or that will give you. That's what I'm looking for. What I see here is evident that you did register. I don't think that's in this state. And a logbook for attendance. Just turn back to this. A logbook for attendance. I want to tie your request to their promise. That's what I'm trying to do. So after the program, they give you cash money?
After the program? No, there was no cash, sir.
So they didn't give you money? No money?
No. After the training. After the training, sir. They said they will set us up. They will set us up with what we can do to help ourselves. That is when the starter pack came in.
And this one they didn't give you?
No.
They only give you a set of knives and...
Just one knife and a set of spoons. And why these rates were given to others?
All right. All right. You want to say something? Are you together?
Yes, sir.
You also want to be complainant?
Yes, sir.
So why did you sit there? Why did you sit away? You have something to say? You have something to say?
Yes, sir.
Put down that oath.
Do solemnly swear that the evidence I shall give before this distinguished committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. So tell us, what do you want to say?
We did this training, sir, in 2022, 19 September. Started 2022, 19 September. With the promise that after the training, we'll be giving starter pack. So last year, they gathered us up at Akoko Stadium, just like stated here. So they were giving starter pack. We went there with our uniform, everything. So we indicated our interest. So we stayed till at about 7 p.m. to 8 p.m. They were giving some persons, because they will call your name, you come get your starter pack and go. So when it got to like 7:30, 8 p.m., the people said we should go, that we should come back the next morning for our starter pack because it's late already. So on getting there at about 6:37 a.m., We were there already, we that didn't get our starter pack. On getting there, we didn't see anything. The only thing we saw were just little things like the spoon, knife, and other equipment. So when we went there to get our starter pack, they said it's finished. We said no. When we left here with a lot of equipment here. So, and you people said we should go there, you want to close up. We want to close for the day because it's getting dark. So when we came back, the dad said we should come. They got our clearance form and gave us a set of spoon and a knife. So when we were complaining, they had to send the policemen to drive us out of the place.
All right, very good. But, did you write to this agency?
Yes, sir.
Any response of them?
They acknowledge. No,
They are not there. They are not here. And no excuse at all. Okay. All right. We will adjourn this case and invite them to come. All right. If when they come the next time they will explain, they don't come, we know what to do. All right. So this case is adjourned. Adjourned. Are we going to do it? Okay. It's adjourned until the next hearing date. We will communicate to you when the next date is.
Case number 4 is from Obong and Okon Etim, Mfon. On behalf of Tukura Family Vessels, Rutail Managed Limited, in the second hearing, and the case number 5 is from Dr. Samuel Udonsak and Honorable Barrister Bassey Dan-Abia, Vessels, Rutail Managed Limited. The first hearing. The two cases are considered for this hearing. Samuel, please take a seat. Please take a seat. Rutail says.
I, Dr. Samuel Udonsak, do solemnly swear that the evidence I shall give before this distinguished committee shall be the truth, the whole truth, and nothing but the truth, so help me God.
I, Honorable Barrister Bassey, do solemnly swear that the evidence I shall give before this distinguished committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
Turn off your mic. Turn off your mic. So, sir, I take that you're not going to give any evidence in this case, right? Sir, I take it that you're not giving any evidence in this case. Are you? Are you, sir? No. Please come and sit down.
I, Dan-Abia, Esquire, do solemnly swear that the evidence that shall be before this distinguished committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
I, Chief Okon, Okon, do solemnly swear that the evidence I shall give before this distinguished committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
I, Obong, Honorable Etim, do solemnly swear that the evidence I shall give before this distinguished committee shall be the truth, the whole truth, and nothing but the truth.
Thank you. Which side represents Obong, Okon, Eche, Mfon on behalf of Atia? This is Atia. How many of you?
It's really fun because I'm talking petition on it.
So the one that represents Atia?
Yes, okay.
Who represents Eche People's Union?
Yes, sir.
How many of you?
It was.
So you guys represent Rutail?
Ruitai.
Rutail. Okay. Rutail. Okay. All right. Let me hear from my left. Let me from Atia first. Why are you here? Please sit down.
Thank you, Denis. I came here, I wrote a petition to this honorable committee sometime October 2024 about the activities of Rutail in the environment at Yard, precisely. That's the first year, this was my job. Unfortunately, I got the invitation last night, so I couldn't come with my counsel to give me a full representation. So this is a very serious matter.
So you're not ready?
Yes, sir.
All right. Let me hear from Eche people. Please fly here.
The chairman of this committee, other distinguished senators here present. I'm here on behalf of Eche People's Union, comprising the Eche people in Eche and Eche local government of Akwa Ibom State. And we are presenting this memorandum to the Senate Committee on Ethics, Code of Conduct, and Public Petitions in the committee's public hearing on the illegal mining of solid minerals in Utiaruk barracks, the village in Eche local government area of Akwa Ibom State. As a preamble, sir, the Eche People's Union is the apex socio-cultural union research, intellectual and leadership platform of the Eke people of Eke and Eke government area of Akwa Ibom state of Nigeria, commonly called the Eke people. In its petition dated 28 November 2024, an address to the President of the Senate through distinguished Senator Okon Samson representing Akwa Ibom South Senatorial District, we complain about the illegal mining of solid minerals called ilmenite in Atia village, otherwise called New Barracks, in Eche local government area of Akwa Ibom State. The illegal mining is carried out by a Chinese company called Ruitai Mining Company Limited. Today you have invited me to a public hearing on our said petition. On behalf of the people of Atia and Eke villages in the environs, who will suffer the direct negative environmental, economic, cultural, health, and social impact of the illegal mining, and on behalf of the Eke people in general, who are the ancestral owners of the Stop Creek Forest, in which the illegal mining is being carried out, the EPU here submits this memorandum, embodying our grievances and facts, supported with exhibits as set out in the annexures hereto. Illegal mining. Failure to obtain letter of consent from landowners, occupiers, in violation of the provisions of the Minerals and Mining Act 2007. The mining lease, Atia village, also called New Barrack, is an Eke community of which the Eke people are landowners and the occupiers thereof. The Minerals and Mining Act 2007 lays down the condition for the grant of mineral lease licensed by the Federal Ministry of Solid Minerals Development. One of these prerequisites is that the intending applicant for a mining lease shall obtain a letter of consent from the landowners, occupiers. But in violation of this provision, Rutail Mining Company Limited, hereinafter referred as to the company, refused and neglected to consult, negotiate, and obtain letter of consent from the landowners, occupiers. It is quite preposterous, unfortunate, and sad that in a sovereign state like Nigeria, foreigners can do whatever they like, exploiting our mineral wealth in connivance with government officials and regulatory agencies, notwithstanding the national security and the economic risk such acts pose to the nation. The environment. Section 2 of the Environmental Impact Assessment Act, the EIA Act, restricts the undertaking or embarking on any project of such nature as requires environmental impact assessment, which includes mining, without first carrying out a thorough environmental and social impact assessment, ESIA, of the effect of such projects on the host communities. However, in violation of the law, the company proceeded to embark on the mining activities without carrying out ESIA in the mining lease area, the Atia village and environs. The EIA Act provides for the identification of the host communities and identifying the impact that the activities of the project will have on the people and the environment. And the same is to be mandatorily published in the ESIA report, which should also contain remedial measures that will mitigate such negative economic, environmental, health, cultural, and social impacts on the people and the environment. In the circumstances, Since the illegal mining activities commenced, the company has violated these basic provisions of the law, which goes down to fundamental right violations. The company has, by its unlawful acts, violated the fundamental and basic human and legal rights of the landowners and occupiers of the mining lease area by destroying their farmlands, sources of water, sources of fishing and hunting, destruction of unexhausted interest in the area without due compensation, and the general destruction of the means of livelihood of the people. Additional to the above, the illegal mining activities being outside the purview of regulatory agencies and having no social and environmental impact assessment report to regulate it and provide mitigating measures for Utiaruk residents and neighboring villages exposes the mining lease area to ocean erosion, air pollution, and other environmental hazards for which we call for urgent intervention of the Senate to save our soul. Below are set out the negative impact which the unlawful activities of the company have caused to the mining lease area at Yanu Barracks and its environs. 1. Environmental effects. Deforestation and land degradation. The mining activities have led to the destruction of forests, loss of biodiversity, and soil erosion, water pollution. The unlawful mining activities have contaminated nearby water sources, posing health risks to local communities and wildlife. Air pollution. The illegal mining activities have released harmful gases and particulate matter, contributing to air pollution and negatively impacting human health. Loss of ecosystem services. The illegal mining have disrupted essential ecosystem services, including water regulation, soil formation, and nutrient cycling and recycling. Social effects. Displacement of communities. The illegal mining activity has led to the displacement of persons, the local communities, loss of livelihoods, destruction of shrines, and cultural heritage. Health impacts. The unlawful activity of the company has exposed local communities to health risks, including respiratory problems, waterborne disease, and mental health issues. Economic impacts. The activities of the company has disrupted the local economy, including agriculture and fishing, and create economic instability and hardship under the already comatose economic situation in the nation. The unlawful mining activity has caused loss of revenue to local communities as their means of livelihood, fishing, farmlands, and migration from the mining lease area has impacted on revenue generation for the scanty people still living there. Environmental degradation, soil erosion, migration of marine life and wildlife, and destruction of the flora and fauna. The entire ecosystems have been noticed since the commencement of the mining activities. Human rights violation. The unlawful and often secretive mining activities have occasioned human rights violations, including forced labor, trespass to landed property, and deprivation of property without due compensation as freely guaranteed under the Nigerian Constitution and international human rights instruments to which Nigeria is a state as a responsible member of the international community, and Nigeria must so act. The question of land ownership. Though the National Assembly wears no paraphernalia of judicial power to hear and determine title to land, but the court of law. However, This matter is so much interwoven and intertwined with the question of land ownership of the mining lease area. And the court of law, having since 1916 determined the question of ownership of the mining lease area, and the same enforced by executive and legislative actions as set out hereunder, the Senate therefore has the power to order all concerned parties involved to adhere to the law. Indeed, as the Senate is the supreme democratic and rule of law institution in the country. Facts and evidence of land ownership. Atia village, also known as New Barrack, is located in a larger area of land known as and called the Stockbridge Forest, also known locally by the Eche people, owners of the land as Akuya, which traditionally, by customary devolution, subsisting court judgments, administrative and legislative actions, is the ancestral land and territory of the Eche people, and is located within the administrative jurisdiction of Esleke local government of Akwa Ibom State. Please see the attached 1913 Talbot's administrative map of Eche district, attached herewith as Annexure 1, which was exhibited in the 1916 case between Eche subtribe and Ibn clan in the case of Utiaruk and Ipa versus Obong and Eche, 1918. Nigerian Law Reports, Volume 3 of the Nigerian Law Reports, pages 10 to 15.
Let me stop here. I'm enjoying, I'm a lawyer. I'm enjoying your, he's a lawyer too. We are both enjoying your submission. But I don't want to be very legalistic here, so that we can cut through the chase. I think I have a good sense of what is going on here. I'm happy to go through what you actually have. Before I continue, we normally don't touch any case that is in court. We don't. My clerk has just brought to my attention that this case is in court. The case that is in court is the case of ownership of the land. That's what is in court. And I'll read the order of the court. It says there are only 3 orders. An order of interim injunction restraining the 3rd defendant and respondent, that's the government of Akwa Ibom State, from assenting to the Akwa Ibom State map establishing bill passed by the 3rd defendant respondent into law, pending the hearing and determination of this case. 2, an order of interim injunction restraining the 1st and 3rd defendant being Akwa Ibom State, 3rd being the government of Akwa Ibom State, either by themselves or through their privies and agents from gazetting the map drawn by the 4th defendant respondent arising from the Akwa Ibom State map establishment law, pending the hearing and determination of the substantive suit. 3, any further order or other orders as the Honorable Court may deem necessary to make in the circumstances of this case. Because there's something you're talking about, because there's something you're talking about mining, and that's the reason why I'm listening. If the order has said anything about mining, I would have answered already. I just want that to be on record, that we are not talking about the land ownership, because that is already before the court. Right? Having said that,
may I respectfully?
I understand. Let me say something. I will say that if I allow you to go to be here until 8 o'clock, and I don't think The reason why people come here is to cut out some of these legalistic things so that we can get straight to the matter. And like I said, we have a good sense of what is going on. But before I say anything at all, let me hear from the mining company.
Excuse me, sir. Just 1 minute. Just 1 minute. Just a minute, sir. Sir, I respectfully like to let us know that there's no aspect of what I'm reading that is in court. There's no map. This is not about the map law.
That's what I said.
It has nothing to do with the law of appliance.
That's what I said.
All right.
That's what I said. I wanted to be on record because when they turned my attention to the matter in court, I quickly read through it and I went through the orders of the court. And the orders of the court are going to say, are going to do with the mining. And I said again, that's the reason why we are still listening to this matter. If the court has given any order at all pertaining to mining, it would have just hands off the matter. Yes.
Sorry. Please, for emphasis, I want to add my voice to that. Once again, I'm the Honorable Barrister Bassey. I'm a former member of the House of Representatives, 7th Assembly. Like I mentioned, I'm a lawyer. Now, for emphasis, we were careful. When we came to the question of land ownership, the couching was clear. You know, though the National Assembly, we're careful about that because I know. But we also saw item 39 of the first schedule part 2 of the Constitution, the exclusive legislatives, and we know clearly it will be upholding issues of mining, minerals, oil fields, and so on and so forth. So we're willing here now to be guided, you know, by the direction you've given us. Now, the issue about land ownership was necessary. If you notice, our petition is second. The first petition came before our petition. And ultimately, like our petition says, there's going to be a point where the issue of ownership will come up. Now, the challenge of the map establishment has nothing, absolutely nothing whatsoever to do with the issue of ownership of the area. The issue of ownership of the area has since been determined by the Supreme Court of Nigeria in 1916, then up to the Privy Council in 1918, and there's several other judgments following that. So there's no contest. We're not in court over the ownership of substance. That's settled. What we're in court for is that the state's government were being sued and were joined on the issue of the map establishment. It has nothing to do with the ownership of substance. But I was also going to, you know, ask for your very kind permission to maybe just go straight to our prayers. Just go straight to our prayers. I'm careful because I notice that the first petition I said he won't go on. And naturally, we should have come after him because theirs is first in time. But if I have your consent and approval, I'll just probably read our prayers before.
Well, I don't get prayers.
What we're humbly asking for, we're praying this very distinguished committee. Number one is to make an order directing the Honorable Minister in charge to revoke the mining license of Ruitai Mining Company Limited until the company complies with the provisions of the law. Because I guess if they didn't have an issue, they will come here. Yes. Number 2 is order Ruitai Mining Company Limited to comply with the law by meeting the Eche people to negotiate for and obtain the consent on the land. 3, compel Ruitai Mining Company Limited to conduct a thorough environmental and social impact assessment, which is a requirement. 4, compel the company to implement sustainable mining practices. The mining activities should be carried out in a sustainable manner and in accordance with international best practice, minimizing environmental and social impacts. Number 5, compel the company to ensure community engagement and participation. That is to say, local communities should be engaged and involved in the mining process, ensuring their rights and interests are respected, void of cheap labor, forced labor, and exploitation. 6, compel the company to mitigate the effect of the mining activities such as provision of adequate means of water sources, economic empowerment, and immediate payment of compensation for unexhausted interest in the mining area which they have damaged, provide alternative fish ponds and other economic enablers for the mining lease area. And lastly, number 7, pass a resolution calling on all authorities and persons in the private to honor the extant laws on the stop street. It's a forest reserve in the first place.
All right, thank you. I've taken time to do this prayer, and I must commend you for this prayer. It made our work very easy.
Thank you, Dan.
Very, very good.
Thank you.
Let me hear from the mining company. I hope you diligently listen to what you said.
Yes, let's change it. Thank you very much.
But let me ask a very fundamental question. Do you have a mining license?
Yes.
Do you have a copy that with you?
Yes.
Can I see a copy? Oh, I'm so sorry. Before we go ahead, my leader, member of this committee, is here. May he introduce himself.
Thank you, my chairman. My name is Senator Barr, the deputy whip of the Senate, and a member of this committee.
Well, can I see? Why?
Okay, thank you very much, the distinguished chairman and members of this committee. Chairman, please, I could actually speak extemporaneously over this matter because the matter is at the tip of my fingers. I want to say, first of all, Mr. Chairman, that the attempt to remove this matter from that issue of the mapping, which they themselves brought in, may not really do justice to us. Why I'm saying that is that we have to go to the root of the matter, which is the local standard of the Eche People's Union to demand of this company. That's the local standard. Do they have the locals? Where are they from? Where is Atia? Is Atia in a local government or in a state local government? Which invariably will take us back to the issue of the map or the attempt to remap Akwa Ibom just to be able to drag a state to the Atlantic Ocean. Atia is borders on the Atlantic Ocean. It's a village that borders on the Atlantic Ocean. So that's what I need to get this committee to know. And Atia is a village in Ibom. Has been an ancient village in Ibom. And as we speak today, I have the certificate of recognition because they mentioned it. They mentioned the law in 1970 or thereabouts. The certificate of recognition that was given by Cross-River State Government of Nigeria to the village head of Atia on the 1st of September 1979. So, 1st of September 1979, this is a certificate of recognition as the village head of Atia. So, in Ibono local government. Chairman, as we speak also, the current village head of Atia is by name Obong Okon. This is the son of the former village head, long deceased, and the certificate of recognition was given to him by Akoko State Government of Nigeria, Traditional Rulers Act 1990, Section 16, Certificate of Recognition, signed in 20th day of March 2003.
You must allow me to finish.
So my chairman, sir, the issue now we are talking about is the company in Eket or Esreket or the company is Libra. Mr. Chairman, I have just sent the mining license where the Federal Ministry of Mines and Steel Development issued a license defining that place and rightly so as a community in Ibadan. That license defines the coordinates as a place in Ibadan. And sir, we have the map of a Bible state released by the Surveyor General of Nigeria in 2024 upon my own application. That states clearly where Eket is, where Esreket is, and where Ibadan is. Now, Mr. Chairman, I must say that sometime during the colonial history, Ibadan was a division in Eket. Even though Ibadan was a division, as so many other divisions of a community in Eket division, so as other communities all around this country. When we got our local government, even though we were a community in Eket, we had our defined places, we had our defined villages. And so, when the local government came, we were given the local government status of our own. And our defined areas and boundaries and villages are ancient villages. So, I don't know, at some point, Dr. Udonsak here, I'm sorry to mention it, has said that they have proprietary interest in Ibadan. How could you have proprietary? In fact, they even mentioned the case of Alfonso Zungoma versus Odili. That has nothing to do. You cannot own a state from a local government that shares no contiguity. That's another thing, my chairman. There is no contiguity between Eket, Esreket, and Ibadan. No contiguity. When they want to go to the river bank, they have to come all the way to Ibadan and take cyclists on the river bank to even the Atia that they are talking about. The Atia is a cosmopolitan place. So as Ibadan, you have Cameroonians, you have Ghanaians, you have Gabonese, you have Chinese, all manner of people live in Ibadan because of the cosmopolitan nature of the community. So the fact that you stay in somebody's community does not give you a right to now say you are the owner of the land. So having said so, now the Rutail company met the owners of the land, met the paramount ruler, met the local government chairman, met the village head, whose certificate I have displayed here, spoke with them, got to do the CDA. I think I've attached the CDA. I have attached a copy of the impact assessment. Is very voluminous, but I think I have something to show. I couldn't brag about. I have something to show that it is there. So the impact assessment is there, that is registered. I even gave to the Akwa State government They have it there. They have it at the Federal Ministry of Mines and Power. So how can somebody saunter in from Ekiti with a preposterous claim that there is no certificate or environmental impact assessment and that there's no license? It goes to show that you don't even know anything about it. And I'm speaking now, the people speaking here, they've never tested salt water. They don't even know where Atia is. If you take him now to Atia, he does not know where Atia is. So how can you come and go to somebody's local government area and say you are the one owning that place, and then that the company is operating there? Mr. Chairman, this is a very shameful thing. And the matter that we are talking about has caused deaths, has caused problems. Houses have been burnt in Ibadan by the people of Ekiti. A lot of things have happened. Mr. Chairman, I came to the 9th Senate to supply a letter to bring a petition asking the Senate to intervene in this matter. I have attached a copy of that petition that I brought to the Senate. I have gone to the National Security Advisor. I have attached a letter. Our lives are under threat always. Our houses are bombed. People are killed day after day, night after night. Our people don't sleep with their eyes closed. So the matter is not just a matter for real-time mining. It's an existential matter also for the security and the safety of the people of the country. I speak as once as the spokesperson of the Ibadan Elders Forum and as the legal advisor of real-time mining. So I'm speaking on that sense concerning this matter, Mr. Chairman.
All right, thank you very much. That's very eloquent, so I'll thank you. Again, there's one thing that I know. Solid mineral is almost like the rights, it's the federal government that has rights over solid mineral. It's not the local government, it's not the state government, just like the oil or gas. And which is why I asked that fundamental question whether or not there is a mining license. And there's one here unless it's disputed. Other than that, then we are taking this for face value that there's a mining license.
Presumption of regularity.
So what I think is left for us is the issue of the prayers that the other side raised. But having listened to you now, you are saying that there are no locals at all to even raise those prayers. So those are issues that is now going straight to the root of who owns the land. I think that is where the conundrum is for me. Yes, you are eager to say something.
Yes, my very brief, response. Sorry, my very brief response. The representative or the village head of Atia, the person who claims is here and hasn't spoken. And the man, he was the one who said he wasn't prepared. And the man who now spoke and went into the issue of the ownership of the land happens to be the Chinese company, Ruitai. That's why, as soon as he started, I said he's not speaking firm on behalf of, But let me just, very quickly, sir, because he's raised legal issues. Please, sir, permit me in 2 minutes. In 2 minutes.
Thank you for even bringing that to my attention. Since it's not ready, I will adjourn this case for you to come back and be ready.
Excuse me, sir.
Are you ready?
Yes, are you ready? There's one observation.
Hold on.
There's one observation, sir. Please, for my safety, sir.
No. I gave the opportunity to say you're not ready.
There's an allegation on the safety of my life. I'm not a village head of Atia, I'm a family. I'm not a village head of Atia before. Okay. They go back and said I'm a village head of Atia.
All right. Noted. right? He's noted everyone. You heard what he said. He said he's not the village head. He's a family in the village. So that is clear. So that he may not be misrepresented. In any case, anything we say here, as we turn on that mic, it's recorded. And so that is clear.
Sorry, can I in just 2 minutes?
Say what now? He is not ready.
I'm not ready.
And since you also alluded to the fact that the mining company
the mining company
is speaking for them, and they say they're not ready, so we need to give them time to be ready. So I will adjust this case for them to be ready. But what I want to put on record, which I have said before, unless there is the issue of authenticity of this mining license, there is none. And it's issued by the authority that has the power to issue it under our constitution, then they can mine. I mean, I hope that is clear, because to otherwise is to create an illegality, something against the law. Like I said, in my mind, I'm confused now because the matter before the court did not speak about mining. He spoke about land ownership.
It doesn't.
Hold on. But your prayers is talking about not even about land. Your prayer is talking about the corporate social responsibility that they owe you, assuming you have rights to that land. That's what it's talking about. And that they didn't see the community as they're supposed to see or to negotiate. But they are saying that your local government or your village or your area is not even contiguous with their own, with where the mine is taking place.
That's why I'm offering.
Hold on, that's okay. No, I will adjourn. So you go and get ready properly. I will adjourn. For us to properly, yes, for this money, yeah, for the company. See, my colleague just called my attention to what happened the first time they were here. That would ask the mining company to come with the chairman of Rutail Mining Limited. What happened to that problem?
I'm very sorry, Chairman. When the committee invited the company first time, I was indisposed. I don't know if the chairman came or not, but as of today, we got this invitation. I rustled up what is before the chairman. What is before the chairman? Just yesterday. The invitation came on Saturday, and we were informed on Sunday. And the chairman is in China as we speak today.
So okay, hopefully we'll come back to go adjourn. Right?
Yes,
you adjourn and then you come. All right. Again, no, can't continue like this, because we're going to save what we want to say to when it's ready. I want the chairman to say so can resolve everything. All right. So we are going to adjourn this matter until the date that my clerk, I have to check the calendar because we are clubbing everything in, until the date that will communicate to both of you. But in the meantime, like I said, this is the parliament, and we uphold what the constitution says very, very critically. So I don't want anyone to be there with the notion that we say they cannot mine. We are not saying that. This license authorizes them to do so. The issue of ownership is in court. I won't touch it. I won't touch it at all. By the time we are able to talk about your relationship with that land, then we cannot begin to talk about your prayers. And I'm hoping that by the next adjourned date, we'll be able to go to the root of that and then be able to resolve it. Even if it's going to be the only case that we are not mind. All right? So this case is going to be adjourned until the date that we communicated to you soon. Thank you. Can I keep this? Can I give this?
Yes, sir. I always.
It is submission.
So last case is case number 7, number 6. Case number 6, Mr. Ezekiel Eriaye and Barrister Stephen Obiefule on behalf of Aketewei family. Versus Share Development Company Limited, now United African Energy Company. This is the first year now. Stephen Obiefule.
First year on the matter.
First year.
Please,
Share Development.
passes is 6. And the passes is still 6. Shell Petroleum Company here. Put them on the order. I'm sorry. Just 1 minute. Why haven't you put?
Do solemnly swear that the evidence I shall give for this distinguished committee shall be the truth, the whole truth, and nothing but the truth and God.
Mr. Ezekiel Eriaye.
Sir, Mr. Ezekiel Eriaye is not here, but I'm here. I apologize for his
You are a lawyer.
Yes, sir. They are on their way to Abuja.
Please, Barrister Stephen Obiefule.
I am.
All right, tell us what you're doing.
Thank you, Mr. Chairman and distinguished members of this committee. I am Barrister Stephen Obiefule, the legal representative, the lawyer to the petitions. So we are here
to approach the Senate, the People's Parliament, to complain about the unlawful, the illegal, the unconstitutional occupation, and of course usurpation of the land of the petitioners, the Aketewei family of Bayelsa State, in the just southern Bayelsa State. Mr. Chairman, sometime in 1988, Shell Development Company Nigeria Limited occupied the land of the petitioners. Until date, we have done everything to get them to compensate the family, which they have failed to do till date. In the course of all this, Mr. Chairman, an oil spill occurred in the parcel of land in question. We approached Shell, notified them, and of course, Msughter, the National Oil Detection and Response Agency, was called in, and there was an investigative report, and visit and report later, which showed that there was negligence on the part of Shell that caused the oil spill. They refused to carry out their civil obligation to the community by sending relief material, and for over 5 years now they refuse to also do that. So mainly, we are here to ask and draw the attention of the committee to the ownership of land which belongs to this family, the Aketewei family, and we have a subsisting court judgment to this effect. We were at the House of Representatives last year. We drew the attention of the committee to this effect. We wrote Shell, wrote the committee. We gave copies of the judgments, the subsisting court judgment, to the parties. Shell Development Company Nigeria Limited, now Renaissance Group. They said they do not understand the content of the judgment. And just as we were pursuing them, dragging them before the committee suddenly adjourned Synodi, and Shell stopped appearing, because Shell stopped appearing honoring the summons. So that is why we have approached the Senate to seek redress and justice for the people and family of Aketewei in Andiama community in Bayelsa State. Of course, for over 37, 38 years that they've occupied the land, carrying out oil exploration and exploitation, we are praying this honorable committee of the Senate to compel Shell, now Renaissance Group, of course, Renaissance Group, having acquired them, would have done so in all intents and purposes, knowing of their liabilities and assets. So we have asked for 100 million naira, 100 billion naira compensation for the occupation of this land of the Aketewei family for close to 40 years now and running. And of course, we have also asked in our prayers that they should send relief material to recognize the family on the strength of the subsisting court judgments as the owners of this parcel of land. Recognize them and they pay adequate compensation that we have asked.
Thank you.
Thank you, sir.
Please come up to your mic. Madam, what's the name again?
Chairman, my name is Abita.
What is your position?
I manage interface with the National Assembly, both House of Representatives.
Say that again.
I manage interface with the National Assembly.
You manage the interface?
Yes, our relationship with the National Assembly. I'm head National Assembly Relations for Renaissance.
Oh, you are the head of National Assembly
Relations
for Renaissance,
yes,
which is the company in question. Yes. I'm just wondering whether or not you have the authority to speak for them.
Yes, my MD is unavoidably absent. As you may have aware, there is NOG currently on.
Say that again?
NOG, Nigerian Oil and Gas Conference is currently on. Actually, Renaissance, the Shell Petroleum Development Company of Nigeria Limited just moved into Renaissance Energy. So the unveiling is today at the NOG.
That's why it's not here.
That's why it's
All right, because
I have a letter.
So can I have that?
I think this.
Eh? This. Yeah, that's what I have a letter to say. The letter is saying that you should represent them.
Yes. Yes, sir.
Okay, so if we make an order here, can you enforce it?
Well, I said they had the National Assembly relations.
You cannot. You cannot. You cannot make those decisions, those overreaching decisions for the company. You had said they're asking for 100 billion.
Well, I thought that this is a process. And
100 billion. They said they're asking for 100 billion. So assuming we say no, the 100 billion is too much, pay the 100 billion. Will you be able to say yes?
We said that I won't be paying the 100 million on the spot, yes, so, but I won't take the message back to the management.
No, I don't want the message back. You are a liaison between National Assembly and so you know how serious we are here.
Yes, I know.
You know what time is it now? It's almost 6 o'clock. I've been here since 10 a.m. I've been here since 10 a.m. And I'm still sitting here. When you all have gone, the report will be written. So this is we are very serious in this committee. We have to be very serious. Like you wrote a letter, if you had told me, if this letter has stated that because he's otherwise engaged, you won't be able to be here, but you are here to communicate that to us, that I will consider very respectful. But for you to tell me that you will be representing the company as a liaison officer to represent Renaissance on a matter this important is wasting of my time.
Distinguished Senator,
yes.
We have a written response to the petitions. We have also submitted that. Like he said, this matter was before the House of Representatives.
Well, that's said.
And we had attended every single.
That was in 2024.
Yes, sir. And we attended, contrary to what he said, we attended every single. I was surprised that he said we were not appearing.
So what was the determination of the House of Representatives?
It was not complete. It was adjourned sine die. So after it was adjourned sine die, I don't know if we're supposed to be attending without invitation. Yes. So it was adjourned sine die. We attended, including in the office of the chairman of the committee, we attended every single.
So you have adjourned sine die.
Yes.
All right. So that is not the true position, please.
What's the true position?
The Shell Development SPDC stopped attending honoring invitations. That was why the committee had to adjourn sine die. Even we got to the point of ADR. The committee invited us for ADR. At a point, surreptitiously they just stopped coming. When you write them, they don't come, and that was when the committee got confused.
Let me cancel. The chamber that I know, if they just stop coming without doing anything more, you would have issued a subpoena already. The chamber that I know would have issued a subpoena for them to appear. I'm going to find out from the chamber the position of this matter. And for that reason, I will adjourn this case for me to move further to see what House of Representatives has done in this matter. And that's going to determine what step that will take next. Alright? So this case is adjourned until the date to be communicated to you.